I'm joined by Donata today. She's going to be talking about the 3 things you need to know about privacy.
Awesome. Thank you. So, hi, everybody, and thank you so much for joining my talk. As Josh said, my name is Donata Stroink-Skillrud, and today we're going to talk about the 3 things that you need to know about privacy. So, we'll be dispelling some myths, debunking some false ideas, and giving you a great overview of the whole privacy thing and what you need to know. And before we start, even though I am a lawyer, I did want to say that anything that we talk about today during the presentation and the questions is really presented to you for informational purposes only and is not legal advice. So if you want legal advice, I would definitely talk to your attorney or find a local attorney in your area for that. So today we're going to be talking about 3 things you need to know about privacy. So which websites need to have a privacy policy so that you can easily spot if a website that you're building or your own website needs to have one, why privacy policies are important, and why you should be the one to talk to your clients about privacy. So before we start on the substantive portion of today's presentation, I want to talk to you about myself and why I'm the right person to talk to about privacy in the first place. So I'm a privacy and technology attorney and a certified information privacy professional. I'm certified by the International Association of Privacy Professionals. I'm also the president of Termageddon, which is a software as a service that has generated thousands of privacy policies and kept them up to date with changing legislation. And I'm the legal engineer behind the policy questionnaires and text, and I'm responsible for keeping the policies up to date with changing laws. So a big portion of my day is spent tracking privacy bills and privacy laws and seeing if there are any changes, and we'll kind of spend some time talking about that a little bit later today. I also serve as the vice chair of the American Bar Association's e-privacy committee and the chair of the Chicago chapter of the International Association of Privacy Professionals. I've also taught classes on Europe's privacy law, the General Data Protection Regulation at the Illinois State Bar for other attorneys as well. Now, even though it's not necessarily related to this talk, but since I am a beekeeper, and since I am a beekeeper, I just want to insert that into every conversation that I'm a part of. So down there, you'll see a picture of me and my lovely bees, who thankfully survived this frigid Chicago winter. All right, so let's get started on the first part. So what websites need to have a privacy policy? And there are a lot of misconceptions on this topic, unfortunately. So some people think that only e-commerce websites need to have a privacy policy. Others think that you only need one if you're selling information or if you are sharing it. And those things are just simply not true. So let's see how you can easily spot a website that needs to have a privacy policy, or how you can easily identify if your website needs to have one. All right, so since I'm a lawyer, I had to get at least one definition in here, and this is the only definition in this talk, and you won't be quizzed at the end. But the one definition that I thought was really important to include here is personally identifiable information, also called PII. So PII is really any data that could identify somebody. And examples of PII include name, email, phone numbers, and physical addresses. Also, IP address is a great example of PII as well. And any website that has a contact form collects personally identifiable information, or PII. So here's an example of a contact form. So this is a contact form actually from our own website. And as you can see, the form collects names and emails, which are examples of PII. So this form collects PII, and the website that has this form obviously collects PII as well. Now, if you want to check if your website collects PII, or a website that you're building for a client collects PII, what I would do is I would go through the website and look for forms. So look for contact forms, email newsletter sign up forms, account creation forms, billing portals, all of that kind of stuff. So all of those forms will be collecting PII. And then also, if the website has analytics installed, That's how you know it collects PII as well, because analytics typically collects IP addresses. There are some privacy-focused analytics services that don't collect IP addresses, but most do. So really, if you're looking through the website, look for forms and look for analytics being installed. And if that's the case, then you'll know that PII is being collected. Now, this is probably the most important part of this presentation. And if you really don't remember anything else from what we talk about today, I really hope that you remember this. So any website that collects PII needs to have a privacy policy. So it doesn't mean share PII, it doesn't mean sell PII, it doesn't even mean use the PII that's collected. The moment that a website collects PII, that's when it needs to have a privacy policy. All right, so that was the first part. So that's how you can easily tell if a website needs to have a privacy policy. So let's move on part two. So why does PII collection and privacy matter? So some of you that have been in the web world for a while might be thinking to a couple years back, maybe 5 or 10 years back, and privacy wasn't really that big of a deal back then, unless you were in finance or if you were in healthcare, right? So if you're thinking about what you did in 2015 or 2010, you might remember yourself copying and pasting somebody else's privacy policy, or getting some free template online, maybe changing a couple words to fit your company name, and then putting that on a website and then calling it a day, and nobody ever looked at that privacy policy again. So you might be attending this talk and thinking to yourself, all right, well, nobody really cared about this, so what has changed? And two things have changed. So in 2018, that's kind of when the privacy landscape evolved into what it is today. So two things happened in 2018. So first, European Union's privacy law, the General Data Protection Regulation, went into effect. That's a privacy law that provides certain rights to EU residents. And at that time, there was a lot of press going on about GDPR. Everybody was really concerned about it. And consumers kind of saw that as, all right, like all of these people in the EU get these privacy rights. And if they weren't located in the EU, they're like, well, why am I not getting these rights? That's interesting. What am I, chopped liver over here? So that's something that kind of brought privacy into the consumer mindset because it was just all over the news. And then second, and probably the most importantly, in 2018, the Cambridge Analytica scandal broke. So most of you being in web probably have heard of Cambridge Analytica and what happened. But if you haven't, basically the firm Cambridge Analytica scraped Facebook profiles of millions and millions of people for their personal information and essentially used that information to target political advertisements. And when that kind of came out, when that story broke, consumers were really taken aback because it was the first time that they really saw the dangers of sharing their PII with certain companies like Facebook and saw how dangerous that could potentially be. Now, because of that, consumer attitudes towards privacy changed, right? So consumers started becoming concerned about their privacy online and the sharing of PII online and what companies do with their PII online. So they basically started pressuring their legislators to propose and pass privacy bills because they wanted to have protection to make sure that this didn't happen. So a great example is a study by Consumer Reports, which found that 68% of Americans say that companies should be required to delete PII upon request, and 67% want tougher penalties for companies that do not respect privacy. So that really changed consumer attitudes towards privacy. And here's the unfortunate part of what happened as well. So in the scandal, the two companies that were involved, Facebook and Cambridge Analytica, collect the PII of millions and billions of people and have billions of dollars in revenue. And you would think that consumers would see this as big companies collecting my PII is maybe not the best idea, or I'm nervous about what they do with my PII and who they share it with. But unfortunately, consumers saw this as an issue that faced all businesses regardless of their size. So it wasn't just the large companies that are starting to become regulated. Small companies ended up getting stuck in this regulatory net as well. So if you're running a company, or if your clients are running a company that don't collect the PII of billions of people, it's something that you still need to pay attention to and comply with. So that's really what's changed in the last couple of years in privacy. Consumer attitudes have really, really evolved from 2015, 2010 to what they are today. So why does PII collection matter? Apart from consumer interest in it, privacy laws regulate the collection and use of PII. And privacy laws require websites to have a privacy policy that makes certain disclosures. So there are a lot of different disclosures that are required depending on what privacy laws apply to you or apply to the business that has the website. But the meat and potatoes of a privacy policy are basically contained of what PII is collected, what is done with that PII, and who the PII is shared with. And those disclosures, that's what's made in the privacy policy. Now, some laws require some more obscure and unintuitive disclosures. So a great example would be, how do you opt out of the sale of personal information? And that information needs to be disclosed in a privacy policy, regardless of whether information is sold or not. And that's Nevada's privacy law. So it's drafting a privacy policy really depends on what privacy laws apply. So if when you created your privacy policy, you didn't know what privacy laws apply to you, or you just took a template that complies with GDPR and nothing else, that's something that's probably not compliant with all the privacy laws that you need to comply with. So there are several privacy laws that are already in place that apply to the collection of PII by websites. And I won't really bore you through going through each of all of these, but I do want to make some points here. So privacy laws have a very broad application, meaning that they can apply to businesses outside of the state in which they were passed or the country in which they were passed. So privacy laws really protect consumers and not businesses. So that means that if you are collecting the PII of residents of certain states, if you're doing business in certain states, if you are offering goods or services to certain states or countries, or if you're tracking the behavior of certain individuals online, that's when you need to comply. So if you're not located in any of these states or countries, that doesn't mean that you're off the hook. They do apply outside of the states and countries in which they were passed. And I think a great example of that is the California Online Privacy Protection Act of 2003, also called CalOPA. And that one applies to any website that collects the PII of California consumers. Now, as you know, being in technology, anybody from anywhere could submit their information on a contact form, right? They could just find your website and go there. So that makes this privacy law so broad, it can apply to pretty much any modern website with a contact form. So that's something that's really important to remember. Now, just to illustrate how quickly things are changing, about 3 weeks ago, Virginia passed its privacy law, the Virginia Consumer Data Protection Act, or VCDPA. And that one goes into effect in 2023, but it kind of just illustrates how quickly things change. And that one applies to persons that do business in Virginia or that produce products or services that are targeted to Virginia residents and that control the data of at least 100,000 Virginia consumers, or control or process the data of at least 25,000 consumers and derive over 50% of gross revenue from the sale of personal data. So that's something to remember, and that's something to prepare for as well in 2023 if that law applies to you. Now, one question that I get a lot in these presentations or just whenever I talk to people is, I guess it's not really a question, it's more of a statement. GDPR applies to me. Everybody thinks that GDPR applies to them, and that's not the case. So, if you have that question in your mind, I would like to answer that right now. So GDPR applies only in certain circumstances. So first, if you're located in the EU. So if your business is located in any of the EU countries, you need to comply with GDPR. Now, if you're not located in the EU, it applies if you are offering goods or services to EU residents. Having a website that's accessible by EU residents and nothing else is not offering goods or services. There's more to it that goes into that. So great examples would be offering the website in any of the EU languages. So for example, French, shipping to the EU, providing directions to your office from the EU, things like that. So GDPR does not apply to everyone, but there is one aspect of GDPR where a lot of non-EU companies end up getting caught in that compliance net. So that basically will happen if you monitor the behavior of EU residents online. Now, if you have analytics, such as Google Analytics, you are monitoring the behavior of EU residents online, and therefore you need to comply with GDPR. So that's something to keep in mind. That's where most companies fall under GDPR. But if your website doesn't have analytics or anything similar, and if you're not offering goods or services to residents of the EU, and you're located outside of the EU, GDPR is not something that you need to worry about. So it's important to remember that these laws don't apply to just everyone that has a website. There are certain criteria that you will need to meet to comply with these. All right, now what happens when you do not comply with a privacy law? So the penalties for not complying with privacy laws are pretty steep, and they can range from 2,500 per violation to 20 million euros or more in total. Now, in terms of what per violation means, that does not mean per website, and it does not mean per policy. It actually means per website visitor whose privacy rights you infringed upon. So let's say you have 100 website visitors from California this month, and you have a contact form but don't have a privacy policy. That fine would be calculated as 2,500 times 100. And in the US, the fine structure is pretty strict. It's just, the number of people whose privacy rights you infringe times the fine amount. In the EU, they kind of have more of a sliding scale. So they'll take different factors into account, like how many employees do you have? What's your revenue? Have you had previous privacy law violations? And how egregious is this violation? Things like that. But in the US, it's pretty clear, we have that specific fine, and that's what it's going to be fined as. So it's very important to try to avoid these as much as possible, especially for easier compliance matters such as having a privacy policy on your website or getting the consent of individuals when they give you their PII. All right, now this is a fun one. Other states are proposing privacy bills. So because there's no overarching federal privacy law in the US, we have each state taking it upon themselves to protect consumers online. And I think in the EU, they kind of did it correctly, or you guys did it correctly if you're located in the EU. All the countries came together and came out with one set of rules that each country needs to follow. Now, obviously, there are some very slight variations, but it's a very general set of standards that you need to follow. Unfortunately, we're not seeing that in the United States. I think to date, really this year, there's been only one proposed federal privacy bill, and it's getting some support, but not much. And it seems like our federal government is dealing with some other problems right now, thinking of COVID and all of that. So it's pretty unlikely that we're going to see, a lot of movement in the next year or even couple of years on the federal level. So we see all of these states trying to propose and pass their own privacy bills. And this is a privacy bill tracker that I've created. You can actually find this on termageddon.com on our blog if you search privacy bill tracker, and I keep this thing up to date. And it's interesting because when I was selected to speak at this conference, I created my slides, and I think I've updated this like 5 times since my slides were created. I actually had to update the slide yesterday because there was a new privacy law that was proposed. So it's something that is constantly changing. So I won't really go through each of these bills individually, but I do want to talk about some common patterns that you'll see between these. So first, all of these privacy bills would apply outside of the state in which they were passed, right? So that's something that's important to remember. So if you're not located in one of these states, or if your customers are not located in one of these states, that doesn't mean that you wouldn't have to worry about it. It's something that can still apply even if you're not in there. Second, all of these bills would require websites to have a privacy policy, right? That makes certain very specific disclosures, and each bill has some variations on what those disclosures should be. Some of these bills would apply to large businesses only. So they would have some exceptions for, revenue amounts or number of employees and stuff like that. But most of these bills would apply to businesses that are of any size, any number of employees, any amount of revenue. So small businesses are usually not exempt from these. The next one is really important. So some of these bills would allow consumers to sue businesses directly for privacy law violations. Now, if any of you have been following ADA, the Americans with Disabilities Act, and all of those lawsuits, once it became clear that consumers can sue businesses directly for ADA violations, the number of lawsuits just exploded. Because the plaintiff's bar has a lot more time on their hands than your state's attorney general. So they have more time to enforce these laws. So it's something that would definitely happen where we would see more lawsuits if any of the bills that allow consumers to sue would pass. And then lastly, a lot of these would provide certain privacy rights to consumers. So the right to access their PII, the right to delete PII, correct it, right to opt out of direct marketing, the right to opt out of sale of personal information, the right to portability, things like that. So the point of these privacy bills is kind of twofold. So one is to provide adequate and transparent disclosures to consumers through privacy policy. So consumer can decide whether they want to do business with a particular company, taking their privacy practices into account, and whether they want to provide their PII to that company. And then second, to provide certain privacy rights to consumers so that they can have more control over their PII and more control over their privacy. So it's really no longer sufficient to just have a privacy policy that complies with today's privacy laws. You also need to have a strategy for keeping your privacy policy up to date with tomorrow's privacy laws as well. And I think that's what this chart illustrates, is the amount of changes that are coming to the privacy landscape. All right, so some of you may be willing to roll the dice on the privacy laws, the fines, and the lawsuits. So I also wanted to mention a couple of other reasons why I think that you or your client should really care about privacy. So first, consumers are interested in their privacy. A KPMG study found that 84% of consumers said that they're open to new state privacy laws. As more consumers want more privacy laws, more states are going to pass them, because legislators don't really pass laws over things that their constituents don't care about. So the more of their constituents care about a particular issue, the more laws that you'll see that are passed in that area. Caring about privacy can gain you a competitive edge as well. So a study by Axios found that 93% of Americans would switch to a company that prioritizes data privacy. This is definitely something new as well, in terms of consumers actually caring about their privacy too, and also caring enough to actually switch providers and switch companies. So if you don't want to lose customers just because of a privacy issue, it's something to really start caring about. And then a study by Cisco found that privacy concerns can slow down the sales cycle by an average of 7.8 weeks. So that's something important to remember as well, especially for smaller businesses. You wouldn't want to lose business because of privacy as well. And then lastly, I think all of us here, even though we're all professionals and we all have, we all work in our industries, we're all consumers as well. So I think we really should put ourselves in the shoes of the consumer and recognize the fact that privacy is a fundamental human right that shouldn't be abused. You don't enjoy getting those spammy marketing emails every other day from certain companies. You don't enjoy, some companies texting you about certain offers where you never signed up for their list. those things are annoying, and they're annoying for everyone. They're annoying for us, and they're annoying to the consumers as well, and they're annoying to our customers. So we have to make sure that we treat our customers the way we'd want to be treated, which is, respecting privacy, and ensuring that their privacy rights are respected, that they're being provided with the correct information about what you're actually doing with their PII. So lastly, privacy and caring about it is the right thing to do. And, just my opinion, I think we should all kind of take that into account. All right, so let's move on to part 3, why you should be the one to talk to your clients about privacy. You might be thinking to yourself, all right, well, I build websites and I build software and I work in tech. Why is this my problem? Shouldn't my clients already know this? And isn't this the responsibility of their attorney? And I'm not an attorney, so I don't want to take this risk of telling them about all this privacy stuff. So why should you be the ones to talk to your clients about privacy? So the fact is that your clients look to you for guidance on taking their business online. A lot of business owners just don't realize that having forms or using analytics means that they may need to comply with certain privacy laws. They just don't know that. And depending on the sophistication of your customers, some of them might need your help opening an email. Others are probably a bit better, but they're kind of looking to you for guidance on taking their business online. And especially with COVID, more and more businesses are going online that have never really used their website to the extent that they do now. So this is something that's pretty new for them as well. Talking to your clients about privacy can make you look proactive and professional instead of reactive. This is kind of the proactive area. As more and more privacy laws are passed, it's more and more important to make sure that websites are privacy focused and privacy forward, and that they're getting the right consent for collecting information, they're providing the right disclosures and all of that. So let's say there's no privacy laws that apply to your client right now, which is very unlikely. But if a privacy law is passed in the future that requires the consent for processing PII, their email list can become essentially useless because they didn't initially obtain consent. However, if they proactively obtain consent now by having a little checkbox that says, I agree to a privacy policy on all of their forms, that makes them more likely to be able to use their lists in the future. So that's something that's important to remember. Improves client retention and loyalty. Clients tend to connect more with web developers and agency owners and freelancers that help them with all those little small issues that they face. Knowing about this and telling them about this can really kind of form that relationship with your clients. It can also help you stand above your competition. So if other agencies or other developers are not talking about privacy, it's something that you can use to kind of set yourself apart from the pack. And then it can also help you document that you told them and protect your agency as well. And I'll talk about that in just a minute too. And I think what's really important to remember here is that you don't need to be a certified information privacy professional. You don't need to be a lawyer to talk to your clients about this. You don't need to know the name of every single privacy law and know every single acronym and who everything applies to. You don't need to know that. What you really need to tell your clients, if you want to tell your clients, is, hey, I'm building you this website, or I'm creating the software for you, and it's collecting PII because you have a form, or if you have analytics or whatever. And I really think you should look into getting a privacy policy. And that's it. So you don't necessarily need to be an expert in all of this, and you don't need to rattle off everything that we talk about here. You just need to tell them, hey, you're collecting PII. I think you should look into this and get a privacy policy. So let's talk about protecting yourself and your agency, or if you're a freelancer, just protecting yourself. So since you're the one designing and implementing functionality that enables the collection of PII, your clients may look to you for advice on how to protect their business while they're collecting that PII. So even if your client doesn't ask you about privacy policies, you should still document the fact that you told them. I would tell them via email in writing that they need to have one, because as more privacy laws are passed, the likelihood of getting fined or sued obviously increases. And if your client gets into trouble, you don't want them coming back to you and saying, oh, well, why didn't you tell me about this? So telling them in an email is definitely a great way to do so. Telling them in your contract is a great way to do so. And while we're here, even though technically it's not part of this talk, I used to write contracts for agencies all the time back when I was in private practice. And back in the day, I saw some contracts floating around where the contract said that the agency or the freelancer was responsible for the website complying with all applicable laws, rules, and regulations. Check your contracts, make sure that you're not promising something like that, because that's pretty much like a lawsuit waiting to happen, whether it's with accessibility, whether it's with privacy or anything else. Make sure that you're not making that promise. And then also make sure that you're not the one that's copying and pasting competitors' privacy policies and changing things and putting them on your client's website, or make sure that you're not the one actually writing these privacy policies. Because if your client gets fined or sued, that's a surefire way for you to get sued as well, because your client is going to want to blame that on somebody and have somebody else absorb that cost. As we discussed, fines for privacy law infringement can be really high. So if you're the one that's writing these privacy policies for your clients, or creating them through templates or other people's privacy policies, don't do that. You're definitely not getting paid enough to assume that type of risk. So make sure that your client goes to a professional to get this done. All right, so when should you tell your clients about privacy policies or that they need one? The first step would be to tell them when you're quoting new projects. So usually when you quote a project, you quote different forms, things like that. So that's a great time to tell them. Also, if your quote includes like a privacy policy page or terms of service page, that's a great time to tell them as well. Before launch is another great time to say so. So basically when you launch the website or when you launch the software, that's when the PII starts being collected. So that's a great, you should probably do it before, because when you collect the PII, that's when the privacy laws start applying. And that's when there can be a violation and fines and all of that. So before launch is a great time to do it. You can also do it in maintenance plans. So if you are signing up your client for a maintenance plan, it's a great time to tell them. And then really you can tell them anytime, because this is something that's relatively new. It's something that not too many people know about. So your clients might not know that they actually need this. So telling them at any time is also good. All right, I'm gonna just have a sip of water. All right, where do you get privacy policies? There's two places to really get privacy policies that are reputable. When a privacy policy is created, and I've written like thousands of these, so I would probably know. When a privacy policy is created, the first step is always to figure out what privacy laws apply to your client. That's always the first step. And if that step is not taken, then the privacy policy isn't good, because each privacy law has a different set of disclosures that it requires the privacy policy to make. So if you need to comply with GDPR, you get one set of disclosures. If you need to comply with CalOPA, you get another set of disclosures, and so on and so forth. So without knowing what privacy laws actually apply, or without figuring that out, the privacy policy will probably not be compliant, and you're kind of just rolling the dice. So source one is attorneys. So privacy attorneys can write a privacy policy for you or for your clients. Privacy attorneys are usually relatively expensive, I would say. It's a highly focused field, so you'd want to make sure that you're using an attorney that actually focuses in privacy. You can ask your business attorney about this, but chances are they don't have that focus and they don't have that specific knowledge to be able to write a compliant privacy policy for you. If you're looking for a privacy attorney, I would definitely recommend checking out the International Association of Privacy Professionals, so IAPP.org. They have a list of attorneys that they can recommend for you. Since it's expensive, it's a great option for really big clients or clients that need special compliance, such as HIPAA or financial services compliance. But a lot of times it's not necessarily an affordable solution for smaller businesses. Now, if you're going with a privacy attorney, what I would make sure to ask them is two things. So one, what's the initial cost of drafting this? 2, what is your plan for keeping this privacy policy up to date? As you saw, there's a lot of bills out there. There's a lot of changes happening. So if they don't have a plan for keeping it up to date, it's probably not the right lawyer for you. And 3, what is the cost of keeping it up to date? So are they going to charge you extra each time? And how much is that going to cost? Second option, generators. A generator is a software that asks a series of questions and then creates a policy based on the answers to those questions. Generators are usually a faster and more cost-effective solution and can work well for the majority of your small business clients. So it's kind of a more accessible solution for most small businesses as well. So I have some frequently asked questions here, but Josh, maybe if there are questions from the audience, we'll take those first. And here is my email as well. So I'm one of those people, like I'll listen to a talk and then 10 minutes later, I think of all the questions I wanted to ask. So if you have any questions afterwards, feel free to shoot me an email, and here's my email as well.